Hello, this is Robin Phillips, and this is a presentation on the First Amendment, freedom of speech and expression in schools. This is for IL 707 at UNA. This presentation addresses the significance of the freedom of speech and the First Amendment as it pertains to students and educators. It is important to educators because of the strong protection of freedom of speech that is a fundamental right of every citizen of the United States of America. Student rights are protected under the same Constitution as adults' rights. However, as we will see, the courts have recognized differences in what students can do while they are in the school setting. In this critical analysis research presentation, key cases will be shown which should help shape school policies. In this presentation, we will look at these different cases briefly. This is a brief presentation on a broad topic, but we will take a look at each of these cases. First of all, Minersville School District versus Gobatis from 1940. In this case, the Supreme Court affirmed a lower court's decision supporting the school district's authority to require students to salute the flag during the Pledge of Allegiance. This is going to be changed in the next case we look at. Just 3 years later, the Supreme Court reversed the Minersville decision in West Virginia Board of Education versus Barnett, 1943. And this case also validated the idea that students were entitled to some free speech rights. The Barnett case involved freedom of religion and freedom of speech, as the defendants were students who were Jehovah's Witnesses, and their religion forbade them from saluting a flag. Specifically, Barnett expanded the definition of freedom of speech to include an individual's right not to speak against their will or affirm any beliefs against their will. In the events leading up to this case, school students were being forced to raise a stiff right arm in a salute to the flag as they recited the Pledge of Allegiance. So in this Barnett decision, the Supreme Court said public schools cannot require students to salute the flag or say the Pledge of Allegiance if it is against their religious beliefs. Next is Tinker versus Des Moines Independent School District from 1969. In this case, 13-year-old student Mary Beth Tinker, 15-year-old John Tinker, and 16-year-old Christopher Eckhart, and other students peacefully wore black armbands in support of a truce in the Vietnam War. Well, school administrators learned of their plan to do this, and they created a policy against wearing armbands. The students did not remove their armbands, and they were sent home. So, acting through their parents, the students sued the school district for violating their right of expression, and they sought an injunction restraining the respondent school officials and the respondent members of the board of the school district from disciplining the petitioners. They also sought nominal damages. The lower court supported the school district, but the Supreme Court supported Tinker in a 7-2 decision, with the consenting opinion holding that the armbands represented pure speech that is entirely separate from the actions or conduct of those participating in it. In his consenting opinion, Justice Fortis, in the Tinker case, famously stated, quote, "First Amendment rights applied in light of the special characteristics of the school environment are available to teachers and students. It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate." End of quote. So the silent protest was protected and permitted under the First Amendment. But as the courts have acknowledged, these areas can be difficult to discern. In Tinker, the court acknowledged difficulty in ruling in the area where students in the exercise of First Amendment rights collide with the rules of the school authorities. Tinker also gave us material and substantial interference tests. Even in school settings outside the classroom, a student may express his opinions, and there's two conditions: if he does so without materially and substantially interfering with the requirements of appropriate discipline in the operation of the school, and second, without colliding with the rights of others. Three things were considered in this decision. In the Tinker decision, the petitioners were quiet and passive. They were not disruptive, and their conduct was within the protection of the free speech clause. The second thing the court noted was that the First Amendment rights are available to teachers and students, subject to the application in light of the special characteristics of the school environment. And third, a prohibition against expression of opinion without any evidence that the rule is necessary to avoid substantial interference with school discipline or the rights of others is not permissible under the First and 14th Amendments. My understanding of this is that the school authority cannot just shut down an opinion because they think that it might cause a problem, but there has to be substantial evidence of such. A recent case in 2017 was heard in California involving a high school student choosing to kneel during the national anthem. The student initials were listed, or it was identified as VA versus San Pasqual Valley Unified School District. This was a case that was heard in December of 2017, and the United States District Court, South District of California, granted a 7-day temporary restraining order against the school district's policy that had required all students in the district at athletic events that student athletes were required to stand during the national anthem. And so a temporary restraining order was granted against this policy. The reasons given for the restraining order included the plaintiff satisfied the 4-prong test and he is likely to succeed based on Barnett. And second, the plaintiff is likely to suffer irreparable harm because of the violation of his First Amendment rights. And third, the balance of equities and public interest tips in favor of granting the temporary restraining order. As a result of this, the school tabled the requirement. The next case is Bethel School District versus Frazier from 1996. Matthew Frazier was a high school student that used a graphic sexual metaphor in his campaign speech. He was actually campaigning on behalf of another student. Because of this, the school administrators enforced a rule that was in the handbook that prohibited conduct which substantially interferes with the educational process, including the use of obscene, profane language or gestures, and they disciplined him with a 2-day suspension. The Supreme Court said the First Amendment does not prevent a school district from disciplining a high school student for the use of vulgar and offensive language. And in this case, they also, the First Amendment did not prohibit schools from prohibiting vulgar and lewd speech, since such was inconsistent with the fundamental values of public school education. The last case we will look at is Hazelwood School District versus Kohlmeyer. Here, a high school principal had declared 2 articles in the school paper to be inappropriate, and he restricted the articles from being published in the school newspaper. The students brought the case to court and alleged a violation of their First Amendment rights. The court held that the First Amendment did not require schools to affirmatively promote particular types of student speech. Furthermore, schools can refuse to sponsor speech that was inconsistent with the shared values of a civilized social order. And last, in conclusion, the principal did not violate the student's First Amendment by prohibiting the articles from being published, as long as his actions were reasonably related to legitimate pedagogical concerns. So this presentation has highlighted a few cases relating to First Amendment rights and students and educators. And as has been shown, school leaders have a responsibility to protect the First Amendment rights of their students they serve, while at the same time protecting the rights of all other students. Thank you for your time. Here are the references I consulted.